So my name is Heather Lachenauer. I've met many of you already, or I know you from other experiences in life. I am an attorney. I'm a partner with the law firm of Brown and Streza, LLP, and I work in an exempt organizations practice group. My practice focuses primarily on religious organizations, and within that subset of exempt organizations, I focus on institutions of higher education. So I provide service to churches, ministries, secondary schools, but the sweet spot for me is colleges and universities. And so I previously served as in-house general counsel at the University of Dallas, and in my current capacity as a partner at Brown and Streza, I support a few other Newman Guide schools in addition to UD. And I'll pass it over to Gene.
Good afternoon, Eugene Munin. Also, I've met many of you. I practice on my own right now, and I help out Catholic not-for-profits with their work, including colleges and universities. I started off as a prosecutor. I did insurance defense with the Travelers Insurance Company, and then worked in government for many years before starting with Ave Maria University, where I was the CFO and general counsel for about 8 years. And I was also a lifeguard, if that makes a difference to anybody. So.
And lawyers in-house are kind of like lifeguards or firefighters most of the time. So with that, without any further ado, we'll get started with labor and employment law for Newman Guide Catholic colleges and universities. Next slide, please. So before I go through the agenda, I just wanted to give you a little opener here for Catholic colleges and universities that are faithful to their mission. Everything that we do is in pursuit of a mission with the central focus point of evangelization. So pursuing the mission that was given to us by Jesus to go into the world and preach the gospel to every nation. And then when we apply that to labor and employment, we can hearken back to kind of a fundamental scripture passage that we might consider for labor and employment issues. In the beginning, God created man and woman in his image and blessed them with a twofold commandment, to be fruitful and multiply, and to fill the earth and subdue it. So human beings were thus called to a singular vocation, to work. Perhaps nowhere in the law, though, is there more omnipresent the proliferation of federal and state regulations. So the law really loves to regulate employment and the work that we do. So we are going to frame our topic today broadly. For Catholic colleges and universities, employment law is not simply about avoiding lawsuits. That's not what we're here about. It's about governing your institution in a way that is legally disciplined, pastorally responsible, and authentically Catholic. So the Newman Guide, as we know, exists to identify institutions that are authentically Catholic. And we heard Patrick talk about integrity and kind of framing this our whole topic, our whole conference with the word integrity. I would say authenticity also falls in the same category. So that authenticity appears in employment relationships, whom we hire, how we form employees, how we communicate our expectations, and how we handle difficult situations. So our agenda today will proceed as follows. First, we'll talk about Catholic foundations and the labor and employment landscape. Then we'll talk about legal protections, so what is available to you as a Catholic college or university, from the church autonomy doctrine to the ministerial exception, which are both constitutional doctrines, Title VII, Section 702, and then the Religious Freedom Restoration Act. Next, we'll go on to anti-discrimination and religious identity, so we'll talk a little bit about equal employment opportunity clauses, and they find their way into so many sneaky little places. And we don't want you to use the generic ones. We're going to propose a few examples that would be faithful to Catholic teaching. We're going to talk a little bit about exemptions and federal funding. Then we're going to move on to a topic that's not so pleasant, but omnipresent, reductions in force. And one or more of you may have faced this challenge in the past. It's unfortunately a reality in our climate today. We're going to talk about considerations that include the legal framework for that, accreditation, and Catholic social teaching. Finally, we'll go to issues to watch and key takeaways. Next slide. So what are some of the, next slide. The labor and employment landscape. We'll talk a little bit now about Catholic social teaching. I'm not going to read from these, but I'll ask you to read them yourself. My husband would kill me for putting so many words on a PowerPoint slide. He's a businessman, and he has told me, just put the heading and then fill it in when you say the words yourself. But I thought I would leave these up here for you. They're quotes from Rerum Novarum and Laborum Exurgens, kind of seminal Catholic social teaching documents on work and employment. And the key points to take away here from Catholic social teaching are the intrinsic dignity of work and the worker. Employers must respect each worker's dignity as a person. Work is for the person, not the person for work. Work expresses the imago Dei and shares in the activity of the Creator. So the teaching that the Church gives us about work is not merely an economic transaction. Work corresponds to human dignity, it expresses that dignity, and it increases it. So for Catholic institutions, employment decisions should be understood as stewardship over persons who are created in God's image. This theological foundation informs our later discussions on hiring, formation, compliance, and separation. Next slide, please. So now we talk about the Imago Dei in the age of artificial intelligence. We have the benefit of Pope Leo's seminal, one of his first seminal work, the encyclical Magnificat Humanitas, which he literally just issued. So the key points for our takeaway here when we consider work in the age of AI and human beings, more importantly, in their work in the age of AI, is hearkening back to that kind of fundamental reality I just focused on, that we believe the human person is made in the image and likeness of God, of the triune God. Equal dignity, human rights, the common good, subsidiarity, and solidarity all remain foundational principles for work. So that doesn't change now that we have artificial intelligence. So AI needs to be viewed through the lens of Catholic anthropology. Institutions can use AI tools, but it should not equate machine intelligence with human intelligence or allow efficiency to displace human dignity, prudence, and responsibility. And so just anecdotally, when I started law school at Notre Dame, the dean there brought us into the courtroom, and we were all filled with trepidation and excitement. And she said to us that being a lawyer is a privilege, and it's also a vocation. And that the vocation should be modeled after our patron saint, St. Thomas More, in such a way that we bring professional excellence to our jobs and our vocation as lawyers, but that we also do that in such a way that we have empathy, compassion, and love for the people we work with and the people whom we serve. And so as a lawyer, we should be a different kind of lawyer, and that's the tagline for the Notre Dame Law School, right? That we should be a different kind of lawyer. The difference is that we focus on the person, on the human being, and not just on the professional skill set or the texts that we're studying or the information we're delivering. So in the age of AI, that was the anecdote I thought of, that we need to maintain the value and focus on the value of the human person and not give way to efficiencies, which is going to be very easy to do. So I think it's a slippery slope. We have to be really careful here. Next slide, please. So labor and employment issues are board-level issues. Why are they board-level issues? Well, your board is responsible for the governance of your school, of your college or your university. And that's a whole nother presentation that I'd be happy to talk with anyone about, the difference between governance and management. And many of you are smiling because you've probably encountered this conversation before. The board of trustees of your institution is responsible for your institution's governance. And therefore, the board should necessarily be concerned with your labor and employment issues. Why? Employment litigation. The area that you are likely most vulnerable to litigation is in employment. You are dealing with people. People have differences of opinion. They bring different perspectives to the table. And this is a top source of institutional liability, is employment. So your board should be very aware of the framework in which you operate, how you treat your employees, what policies you put in place. And in some states, like Texas, the board actually has to approve certain policies for institutions of higher education. The governing board has to approve certain policies for colleges and universities. So you should be mindful if your state has that type of requirement for your board as well. Regulatory enforcement is increasing at the federal and the state level. Reputational risk. If you have a problem, your board is going to become aware of it, and one of your trustees might actually be the first person to say, hey, did you see this in the local newspaper? So your board certainly should be aware of issues as they arise. Accreditation standards. All of us know that these wily little things called accreditation standards can really be the bugaboo in your strategic plan. So your board has to understand how employment and labor issues are an obligation of the institution. The board's fiduciary duty is governed by its state laws, but it's also just prudential judgment and best practices. And so this is why the board should be aware of your labor and employment practices. And finally, your Catholic identity and mission rely upon who you hire, right? You're asking these people who you're hiring to carry forth your mission. So they're part of your army. You are not an army of 1 or 2 or 3. You're an army of however many people are working for your institution, and that includes both faculty and staff. Next slide, please. So current trends and issues in labor and employment, real quickly. Regulatory expansion. We have new federal and state laws that expand employee protection, including the Pregnant Workers Fairness Act. We have this incredible move afoot in state law that's related to pay transparency and AI regulation. We also have this movement in many states that are where states are dictating how an employer provides sick leave and what kind of paid sick leave the employer is obligated to provide to members of its staff. And so we would urge you to be sure that you're aware of your state laws, whatever the state laws are in your jurisdiction. Labor and employment, and I should have started with this actually, is vastly governed by state law, state and local ordinances. And so it's really incumbent upon you as leaders of institutions of higher education to consult with local counsel. You'd like to consult with an attorney who's licensed in your jurisdiction, because the local laws are sometimes the most nuanced. Religious liberty tension. There's an increasing conflict between religious employer autonomy and anti-discrimination mandates. We were talking earlier today at our roundtable about a recent case called Zinsky versus Liberty University, and I won't touch upon it here because I believe that Greg Baylor will probably touch upon it later in his presentation kind of broadly on religious liberty issues. But suffice to say that there was an employee at Liberty University who was employed in the IT department and is alleging sex discrimination. And Liberty University asserted a number of defenses, including a number that are based on the university's religious identity, and they lost in the district court. And so it's gone up to the Fourth Circuit for review. But the tension lies in kind of which right trumps which civil right, and which laws can be asserted to protect which civil right. So in other words, if someone says, one of your employees says, this is the way that I am, and my gender identity is the basis that I understand myself, and that's I'm being discriminated on the basis of sex because of my gender identity, and the institution says, well, we have a religious belief that sex is defined differently than the way that you're describing it. Which right does the court grant? Which what law, what legal authority does the court look to? And this is really the tension that the Zinsky case highlights. So I would urge you to pay close attention when Greg describes that later today. Workforce challenges. We have faculty shortages. People have remote work expectations. The majority of people on your campuses likely were sent to remote work during COVID and have never quite returned. So this is a big problem in some circumstances for those who have an educational value or paradigm, pedagogy of being in person and on campus. And then there are generational shifts in workplace culture. So we have young people, we have older people, we have all sorts of different understandings and impulses related to technology, and that can present certain challenges. So you have to be aware of them. Financial pressures. This is a constant, right? And it has been for many years. We were talking at one of the meals the last couple days about how the enrollment, the undergraduate enrollment rates really hit an all-time high in around 2010 or 2011 and have been on a downward slope ever since. And so if you are an institution that relies for 90 to 100% of your revenue on enrollment, then you certainly have financial pressure. So with enrollment declines, there are budget constraints, and that may drive you towards a reduction in force, towards a tightening of your belt, reducing your programs. Next slide, please. This looks intimidating, but I promise it's not. This is the alphabet soup of federal law. So what laws that related to employment are colleges and universities subject to? You're all probably familiar with Title VII, which governs employment. If you are a recipient of federal financial assistance, or if you are not, you're subject to Title VII. There is a religious exemption, which I'll talk about in a few minutes, in Title VII that enables you as a religious college or university to hire for mission. So you can hire someone called a co-religionist, which does not mean they have to be a Catholic. It just means that they have to be someone who believes in your mission. The ADA from 1990, the Americans with Disabilities Act. Now, religious institutions are not subject to Title III of the ADA, which is the public accommodation portion of the ADA, but you are subject to Title I, which has to do with employment. That entirely governs employment at your institutions. And so you're obligated to provide accommodation for people with disabilities under the ADA. The ADEA is the Age Discrimination in Employment Act, the FMLA, the Family Medical Leave Act, the FLSA, the Fair Labor Standards Act, the PWFA, which is the most recent federal statute that you're subject to, is the Pregnant Workers Fairness Act, and then Section 1981 of the Civil Rights Act, which guarantees freedom from racial discrimination in contracting. So this is just a litany of probably the most familiar federal laws that you as colleges and universities are subject to with respect to your employment. And so you want to be sure that you bear these in mind in every interaction that you have with an employee. State and local laws, you have to be mindful of your state civil rights laws, pay transparency laws. As I said, sick leave, this is a really big deal right now. There's this, I can't emphasize it enough, a big move afoot in state law to require an increase in paid sick leave. There are non-compete restrictions, state by state, AI and hiring laws, and whistleblower protection. So if someone, says that there's a problem with the institution, then they may be protected from being fired, and it may be considered retaliatory if they are let go. Finally, there's religious protection. So in the legal architecture of a college or university that is Catholic, you have to bear in mind the First Amendment. Congress shall make no law respecting the establishment of the establishment of religion, nor prohibit the free exercise thereof. First Amendment. The church autonomy doctrine and the ministerial exception both flow from the First Amendment and provide you as religious institutions with certain protections, which we'll talk about in a minute. Title VII, Section 702, RFRA, both the federal and on the state level, and then state religious freedom acts. So these are, this is just the kind of the layered network of laws and regulations that you should be mindful of, that your council should be mindful of, and should constantly keep you apprised of. Next slide, please. So legal protections for Catholic institutions. Let's go right into the church autonomy doctrine. as I said, the First Amendment to the United States Constitution says Congress shall make no law with respect to the establishment of religion, nor prohibit the free exercise thereof. So here, we want to understand a little bit better what this constitutional principle is of the church autonomy doctrine. This one and the ministerial exception are of vital importance to employment matters for your institution. So the church autonomy doctrine protects a religious institution's internal religious governance. Basically, it says that a civil court cannot reach into matters that are ecclesiastical in nature. And this is particularly with respect to hiring or firing or discipline, any kind of employment issue. So the U.S. Supreme Court has long recognized that the religion clauses of the First Amendment protect a religious organization's right to decide for itself, free from state interference, matters on what are called church government, as well as those of faith and doctrine. The court made this clear in the 2012 unanimous decision in Hosanna Tabor Evangelical Lutheran Church and School versus the EEOC. How many people have heard of Hosanna Tabor? Okay, so you're familiar with the case and hopefully with the holding that the court said and recognized that institutional religious freedom, which is referred to generally as the church autonomy or ecclesiastical abstention doctrine, includes the right of religious organizations to choose their ministers, which the court described as those who will preach their beliefs, teach their faith, and carry out their mission. So Chief Justice Roberts delivered the court's decision there, and he emphasized that when they were implemented, the religion clauses ensured that the new federal government, unlike the English crown, would have no rule in filling ecclesiastical offices. The Establishment Clause prevents the government from appointing ministers, and the Free Exercise Clause prevents it from interfering with the freedom of religious groups to select their own. So Chief Justice Roberts, in the Hosanna Tabor opinion, shared an anecdote from 1806 involving James Madison, who is considered the leading architect of the religion clauses of the First Amendment, in which Madison advised John Carroll, who is the first Catholic bishop in the United States, that the decision as to who would be appointed to direct the affairs of the Catholic Church in the newly acquired territory of the Louisiana Purchase was an entirely ecclesiastical matter left to the church's own judgment. And Madison explained, in quotes, the scrupulous policy of the Constitution in guarding against a political interference with religious affairs prevented the government from rendering an opinion on the selection of ecclesiastical individuals. So that's pretty strong language from our friend, Mr. Madison. While disclaiming a rigid formula, the Supreme Court based its application of the ministerial exception to the plaintiff teacher in Hosanna Tabor, and did this based on four primary considerations. Namely, first, how the employer held out the employee, including her title. Second, whether the employee had undergone significant religious training. Third, how the employee held herself out. And fourth, what functions she actually performed. So the opinion concluded that the ministerial exception should apply to any employee who leads a religious organization, conducts a worship service, or serves as a messenger or teacher of the faith. So these are really important principles for you to embed within your employee handbook, within your offer letters, within any document in which you set out the expectations that you have for those whom you would consider ministers under this legal doctrine. So I've actually encountered faculty members who've said, I'm not a minister. You can't call me a minister. You can't put it in my offer letter. I'm not a minister. And in the Catholic Church, we know that for us, priests are ministers, deacons are ministers, we have lay Eucharistic ministers. We don't consider it, we're very different from the Church of Christ, which is the religious entity that is at Pepperdine, animates Pepperdine University, close to where I live. very different. In the Church of Christ, many more people can be considered ministers, and they have a very robust minister housing program because they have about 120 ministers on campus who are all lay people, but they're considered religious ministers. So Catholics are different, and your faculty will respond in kind. So I wouldn't recommend going out and putting it in all their offer letters. You're a minister of the church now. I anoint you minister of the church. But if you ever have to use the defense of the ministerial exception, you can do that without even naming them as a minister, as long as you've set out the expectations that they are going to be a champion of your faith, of your mission. And so that's really important to put in the documents that you have. Next slide, please. So I just talked a little bit about the ministerial exception. The only thing I would add there is that for purposes of the ministerial exception, a school should focus on the functions performed and the religious significance attached by the faith community to the employee's role, rather than the title alone. So evaluate early whether the ministerial exception is likely dispositive, and where applicable, raise it promptly as an affirmative defense. So in a recent case out of the Fourth Circuit, Billard versus Charlotte Catholic High School, the court concluded that a religious organization may not waive the ministerial exception defense. So it's not waivable, is what the court said. And in that case, interestingly, Charlotte Catholic said, no, we don't want to raise that defense. That's not one of our defenses. And the court said, sorry, it's already there. It's there. It's a jurisdictional defense. You can't waive it. So the Fourth Circuit stated the exception is structural. It's a non-jurisdictional defense that protects the institutional separation between civil courts and churches and allows appellate courts to raise it sua sponte in order to avoid unconstitutional entanglement. So in sum, the doctrines of church autonomy and the ministerial exception are historically rooted safeguards that ensure that civil authority does not intrude upon the internal life of your organization, of your college or universities. So effective counsel, your legal counsel, must integrate doctrinal principles of your faith into governance, policy drafting, and litigation tactics to preserve your religious character and to preserve your legal protection. Next slide, please. So Title VII, Section 702, is the religious exemption that you all can avail yourselves of as religious colleges and university. This permits religious hiring preferences for all positions, not just for clergy or ministerial roles, and it applies to work that is connected with the activities of the college. It does not require that the position is ministerial. So this can apply to your custodial staff, can apply to your landscaping crew, it can apply to your IT department. Title VII of the Civil Rights Act of 1964 is a federal employment statute that generally prohibits discrimination in employment decisions on the basis of race, color, religion, sex, and national origin. But as you see here, there is a very robust religious exemption. So Section 702 is what I've quoted here. There's also Section 703. So there are two religious exemptions in Title VII. Section 702 says this subchapter shall not apply to a religious corporation, association, educational institution, or society with respect to the employment of individuals of a particular religion to perform work connected with the activities of such corporation. This is also known as the co-religionist exemption. What does it mean to be a co-religionist? Most people think it means that you have to have the same faith. The way that courts have interpreted this and applied it is that a co-religionist is someone who supports your mission. So, in concert with the provisions of Ex Corde Ecclesiae, where we say that a Catholic institution of higher education can hire, and in fact should hire, people who are not Catholic, provided that they recognize and respect the Catholic mission of the institution, this is protected by Title VII. So if you hire someone who believes in your mission, You can fire someone if they no longer believe in your mission, and you can assert Title VII and the religious exemption as a legal protection. Next slide, please. The Religious Freedom Restoration Act, I'm sure all of you have heard these letters before too, RFRA, right? We like letters. We like to make acronyms with laws because legislators just can't make them short. So it's easier to just shorten them by acronym afterwards. So RFRA, we have state and we have actually federal. The federal RFRA is probably the most important. So key points here, the government may not substantially burden religious exercise unless it satisfies a standard called strict scrutiny. The federal government must show that a compelling government interest exists and that the government has passed a law that is the least restrictive means of imposing on religious expression. So the federal RFRA applies against the federal government, and many states, but not all, have state RFRAs or constitutional protections for religious organizations. So RFRA is generally raised as a defense. It requires a sincere religious belief, and it requires a showing that there's been a substantial burden by the government in passing the law at issue. Think of it as a shield. RFRA is something a religious college or university may hold up when a federal law or regulation tries to force it to do something that clashes with its core religious beliefs, like how you're running your religious college or university, your summer camp, how you're hiring staff, anything that you're doing, basically. So think of the seminal case here as Burwell versus Hobby Lobby. And many of you are probably familiar with this case. It came out in 2014. The court made its decision. A Christian-owned, closely held for-profit business did not want to provide and facilitate for potentially life-terminating drugs for its employees. And the Supreme Court, in that case, in reliance upon the federal RFRA statute, concluded that RFRA protects any person's exercise of religion and that for legal purposes, a corporation is a person. The government was imposing a substantial burden, and even though the government might have a compelling interest, it couldn't force a for-profit entity to provide the coverage because it was not the least restrictive means. So there could be other alternatives available to the government. Next slide, please. So how do you preserve all of these religious exemptions and your defenses? The best way to do this is in the writing. And you probably have heard this from your legal counsel over and over again. I remember telling many people in the past when I've worked with different institutions that a policy isn't really a policy unless it's written down. So people might say, oh, well, we have this policy and we do it this way. Well, that's a practice, but a policy is something you write down, and that prevents any kind of doesn't prevent, but it mitigates against the likelihood that there would be an allegation of discrimination. So someone coming and saying, well, you treated me differently in this circumstance. And it also mitigates the likelihood of an allegation of bias. And so these are two reasons why it would be good to write things down. So how do you do that? In your governance documents, your articles, your bylaws, your mission statements, your board charters, your board committee charters should expressly state your Catholic identity and your ecclesiastical connection. Your employment agreements include morality clauses, mission fidelity provisions, acknowledgement of religious employer status, your job descriptions, the same thing. Make sure you actually do performance evaluations and evaluate your employees on whether they're faithful to your mission. Are they doing what you've asked them to do in their professional life, but also in their personal life, if that's a requirement that you've set forth? Consistent practice. Apply standards uniformly. Inconsistency in the application of your employment standards is the number one litigation risk for you as a religious employer. Next slide, please. Okay, anti-discrimination and religious identity. Let's go to the next. So the problem with a generic EEO clause. So let's look at this generic secular template. College, let's just call it College B, or let's just say St. Joseph's College because St. Joseph's is one of my patron saints. St. Joseph's College does not discriminate on the basis of race, color, religion, sex, sexual orientation, gender identity, or national origin. You probably have seen this litany somewhere in one of your policy documents. So the problems here are numerous. With this type of statement, you as a religious college or university are waiving your religious hiring preference because you're saying that you're not going to discriminate on the basis of religion, which, as we just said under Title VII, you're entitled to do. You can do that, and you probably should. Undermines the ministerial exception, creates an estoppel against the institution, signals identity confusion to courts. So if an employee sues you and presents this statement to a court, the court will say, well, you say here that you don't discriminate on the basis of religion. We've kind of said discrimination in our culture, that discrimination is a bad word in some instances, but discrimination in a healthy sense, that you're discriminating and saying, well, we're going to hire people who agree with our mission, is actually a good thing. It's not a bad thing. And so you want to make sure that this language is not in your EEO clauses, and they find their way not only into your employee handbook, into contracts that you enter into MOUs, they're everywhere. So we are going to suggest that you take a mission-aligned approach, that you affirm human dignity, prohibit unlawful discrimination, preserve your religious hiring rights, reserve the right to require fidelity, and maintain consistent enforcement. Next slide, please. And how do you do that? Well, this is a really long example. I'm not going to read it for you. I'll distribute the slides afterwards. But we thought we would, and take pictures if you'd like to. The key elements here of what we are calling a dignity-centered EEO clause is that you're grounding this statement in the dignity of the human person in accordance with Catholic teaching. You're prohibiting unlawful conduct. You don't want discrimination that might be in violation of the law, and you are expressly reserving your rights as a religious employer, and you're underpinning or emphasizing a mission fidelity expectation. Next slide, please. The other thing that you want to make sure you focus on is the religious nature of the employee's employment. This is where you would say that your employee is obligated to support your mission in their employment, in their job duties. It establishes that employment is mission connected. It creates an evidentiary foundation for the argument or the defense that this person is subject to the ministerial exception, and it also supports a Title VII, Section 702 religious employer defense in the event that you should need it. But perhaps most importantly, you're recognizing the dignity of this person by telling them what your expectations are, right? So they're not caught off guard. They understand. This is why I'm working at this school, because God has called me here. I'm supporting the mission, and this is what the institution is telling me they expect of me and what I should expect of the institution. Next slide, please. So we have this case called Bostock versus Clayton County, and this was a kind of a tectonic shift, right, in the way we interpret and understand Title VII. So in 2020, the U.S. Supreme Court heard the case of Bostock versus Clayton County to decide whether an employer who terminates an employee merely for being homosexual or transgender violates Title VII's prohibition against discrimination because of sex. Justice Gorsuch delivered the opinion of the court, and he said, in that opinion, an employer who fires an individual merely for being gay or transgender violates Title VII. Justice, and this is just termination of employment. So previously, everything I've talked about applies to all sorts of employment actions, from hiring to disciplining, to promoting, to firing. Bostock is limited to terminating employment. Justice Gorsuch explained that discrimination on the basis of homosexuality or transgender status necessarily and intentionally applies sex-based rules, rendering it unlawful. The majority of the court acknowledged worries about how Title VII may intersect with religious liberties and identified 3 safeguards in the opinion. They identified a statutory exemption. So Title VII, Section 702 does have a religious exemption for religious organizations to hire co-religionists. The First Amendment, we have the ministerial exception, the constitutional doctrine that you can assert as a defense in your hiring and in your employment practices. And then RFRA, which operates as a kind of super statute, is what the court said, that may supersede Title VII in appropriate cases. So the court declined to address those questions, though, the questions of religious liberty, and this was much to the chagrin of many court watchers, many other people who have said, oh my goodness, what's going to happen? What will the impact be? And we'll see it unfold in the future as litigation continues in this area. But the things that the court identified as your religious liberty defenses are those that you should rely most heavily on, and that those are the laws and the doctrines that I just described to you before we talked about this slide. Next slide, please. The other thing that you should consider doing as a religious college or university is to define sex in your policy documents. Now, when I was working with one institution, this became a very large discussion among a large group of people, faculty, administrators, staff, and it kind of took on a life of its own, actually. How much should we say? How little should we say? Should it be an internal policy document? Should it be a published policy document? Whatever your institution decides, I would encourage you to do something, not to not do anything, or to refrain from doing something. And I would encourage you to go to the Ethics and Public Policy Center's Person and Identity Project website, because there they have the resources of many archdioceses and dioceses that have published statements on this subject. So they've defined sex for purposes of employment and in purposes of their handbooks, purposes of all their projects. So the key point to take away here is that as a Catholic institution, you will define sex as biological sex, determined at conception, confirmed at birth, consistent with Catholic teaching. And you'll recognize that every person is created in the image and likeness of God. So tie this definition to the Church's understanding of a body-soul unity and biological sex as an objective, immutable reality. And this is, again, these are things that you'll have to talk about amongst your leadership teams. Next slide, please. So I'm not going to go through this in great detail, but suffice to say that that the policy areas that will trigger scrutiny with respect to how you define sex include housing for students under Title IX, the use of restrooms, athletics, and the NCAA's requirements if you are an NCAA athletics institution, the use of pronouns, counseling services, employee benefits, health services, student discipline, employment decisions. These are the biggest areas of concern for you as a Catholic college or university. Title IX offers a variety of enforcement mechanisms for the enforcement of Title IX, and Title IX is probably the biggest concern if you are a recipient of federal financial assistance to be compliant with. Now, I've listed here also the Cardinal Newman Society's human sexuality standards to define sex according to biological reality, the sexual binary as God-given gift. And again, we encourage you to go to this website, the Person and Identity. And we don't work for the Person and Identity Project, but they just happen to have the best resources, in my opinion. They have a pretty robust data bank. Okay, next slide. And I'll hand it over to Gene.
Thank you, Heather. I know we're going to save some time for questions, so we'll try and go through these slides quickly here. And, you know, everybody has a vocation in life. I don't know how my vocation became to give people bad news, but for the last 20 years or so, that's kind of what I've been doing. I remember this was years ago, I got a 14-year-old son, and he said, "Dad, what do you do for a living?" I said, I tell people things they don't want to hear. That's basically what I do. So we're going to talk a little bit about reductions in force and also about individual terminations, which you may also have to deal with from time to time. So what are the reasons that you may have had reductions in force, or you may in the future have reductions in force? Could be any of the things that, you know, Heather talked about: enrollment decline, program elimination, budget shortfalls, restructuring, technological changes, AI, for instance, strategic realignment, accreditation actions. Any of those could lead to a reduction in force. And when we talk about reduction in force, we're talking about, you know, several people, more than one person that you're making this decision about. And by the way, Heather had also mentioned the virtues, skills of compassion, empathy, and love. Probably nowhere in your work will this ever be more important than when you're telling someone that they're not going to work for you anymore. Okay, so St. Thomas More, whose feast day is next week, you know, I always pray to him when I have to start these meetings, because they're usually obviously devastating news for someone who's not going to be working for you anymore. Okay, next slide, please. Just like with the hiring of individuals, you have federal laws that impact the discharge of individuals. Nice to know if you're over 40 that you're considered an older worker Benefit Protection Act, Title VII. So the same reasons that the same restrictions and the same exemptions that apply to hiring individuals also apply to the discharge of individuals. The same is true with ADA and ADEA. Then there may also be, you know, your individual states. You know, California has, you know, many more. Illinois and New York have more robust anti-discrimination laws. So there may be rules with respect to severance pay and final pay, and, you know, usually you can't deduct things from their final pay if they owe money for any items that you know, may be on the ledger. So you have to be careful about that. And the best thing to do is to document what it is that you're doing. The written business justification tied to the legitimate institutional need. You know, why are you doing this? You need to document that for all sorts of reasons: litigation reasons, accreditation reasons. You need to have that laid out. There has to be objective selection criteria documented before individual selections. There needs to be an adverse impact analysis by protected class. So your outside, you know, you could do that internally. You know, your HR business office might be able to do that, or you could, your outside counsel might be able to perform that task for you. And it's important to keep these decisions under the attorney-client privilege. This is not information that you want to be sharing or you know, make discoverable later on in case there's litigation. Next slide, please. In addition to the litigation concerns that you might have, there are also always, with higher education, accreditation issues. So again, I'll go through these quickly here, but you need to maintain the balance of educational programs. You need to integrate the legal financial criteria with the academic quality, including, you know, program learning outcomes, related required courses, licenses, and professional accreditation, things like that. Everything needs to be documented. You would be doing that anyways, but for purposes of accreditation, you definitely have to do that. Your accreditor may have certain expectations regarding adequate faculty composition, credentials, program coverage, things like that. The decisions regarding these reductions should not just be made by HR or the CFO or the legal office. You need to incorporate input from the provost so that if academic personnel are impacted, again, this will have an accreditation complication perhaps. And then you need to be concerned about any hidden noncompliance issues that may arise. Next slide, please. So it's helpful to have a checklist divided up into the 3 stages: the reduction in force planning, execution, and post. So again, identify your legitimate business and academic justification. You need to engage legal counsel under privilege, define objective selection criteria, conduct adverse impact analysis. And by the way, there may be a slide that says this as well. So, part of the problem is that even if you don't intentionally discriminate, there could be a disparate impact claim against you. So, in other words, if you have 100 employees and 90 of them are Caucasian and 10 of them are African American, and you lay off 6 people and 5 of them happen to be African American, even if you didn't intend to discriminate, there might be a disparate impact claim there. Now, by the way, disparate impact is a issue that's out there with the Supreme Court right now. You may have heard with the Voting Rights Act. They essentially eliminated disparate impact as a tool for a claim. It may happen again also with employment, but for right now it's still part of the Title VII. When you're executing, there are certain disclosures with respect to the OWBPA. You may notice, and we're going to talk, I think we have a slide on severance agreements, that older workers get 21 days in order to review a document. You have to notify them that they should seek counsel with respect to review of the severance document, and they have 7 days in which to revoke their signature. So there are certain rules with respect to older workers that you have to be cognizant of. And we talked about the severance agreement. There needs to be a communication sequence. The board, as Heather mentioned, has to be involved in a decision regarding a reduction in force. That's definitely a governance issue. Leadership and affected employees. And by the way, affected employees are both the employees that are losing their jobs and the employees that remain as well. And ideally, best practice is to have outplacement and counseling or pastoral support resources available for people who are losing their jobs. And then after the reduction in force, you need to monitor for any retaliation claims, document retention of reduction in force records, and there needs to be a communication plan, a morale plan for those who are not being laid off. Next slide, please. So here's the severance agreement slide, and generally these things are thick and detailed. You know how lawyers are. They like to have more words are always better than fewer words with lawyers. So, but the idea is to protect you. The worst thing that could happen, well, not the worst thing. One bad thing that could happen is that you go through all of this and you give someone a generous severance agreement, and then they turn around and sue you anyways and succeed. So you don't want to do that. You want to avoid that. So you have to have a very robust, comprehensive set of waivers in there, general release, and that and there are here's the OWBPA requirements that it has to be 21 days to consider, 7 days to revoke the signature, 45 is if there's going to be a group, a large group of those that are being subject to a reduction in force. Consideration, severance pay, benefits, continuation, outplacement. By the way, always a good idea to have a policy in place regarding severance, and I think it's safe to have it based on level and salary. There's not a problem with that, but it is a problem if you're just deciding on the fly to give 6 weeks to this person and 8 weeks to that person. You're going to subject yourself to a discrimination claim invariably if you don't have a policy in place ahead of time that is applied consistently when you have these kinds of situations. Non-disparagement clauses, confidentiality provisions. I like to make those mutual. There's no sense in trying to make this thing completely one-sided. Return of property and data. This is often a annoying part of this, that you're always trying to track down somebody's laptop later on or their keys later on. It's helpful at the time when you're giving the employee the bad news. Oh, and by the way, when you convey this information, my advice is you should have two people there. You should be the decision maker, whoever's making the decision to terminate, and then a person from HR. I've never really liked the idea of having the attorney sitting there, because the attorney then would become a witness, and you'd rather not have the attorney be a witness. So it's better off just to have two people, the person who's making the decision to terminate and someone from HR. And if there are any legal questions later on, then they can be conveyed to the attorney afterwards. But better to have quickly to get the return of property. Otherwise, it may be a long time before you're trying to find somebody's laptop. Cooperation clause for pending matters, that's great if you can get it. You can imagine the mind frame of people that you've just told don't work there anymore and how willing they're going to be to cooperate with you. But if it works, it works. Depending on their title and their responsibilities, there may be an issue regarding non-solicitation of employees and students, and reference letters. This is also kind of an interesting one. It's not a horrible policy to say that we don't provide references. We'll tell people, if they ask, that this is the date you started, this is the date you stopped working for us, and you're eligible for rehire. That's usually sufficient, and that's probably the safest, because you open up a whole different can of worms when you're being completely honest about someone's performance, and so you need to be careful about that. And just remember that, you're a Catholic institution, right? It needs to be mission aligned. Every decision needs to be mission aligned. Generous severance reflecting dignity of the person is appropriate. Outplacement assistance, continued access to campus ministry or chaplaincy. Again, this is, it depends on why someone is being let go. In a RIF, this normally shouldn't be an issue, and there shouldn't be any restrictions about a person coming back onto campus. But it's possible if you had an individual separation for something very serious that you would ask that they not come back onto campus. Next slide, please. And then we just have some of the Catholic principles, again, that guide all of our decisions. The dignity of the person, subsidiarity, solidarity, stewardship. I'll just say one other quick thing about individual separations. When you have an individual separation, something's gone wrong, obviously. An employee is not performing the way, up to expectations, let's put it that way. My thought always has been, after having done this for 20, 25 years, it's like, if there's any possible way to redeem the employee, to get them up to a level where they can perform, that's obviously the best solution. If it's possible to find them work in a different area, again, not just to move a problem somewhere else, but to help the person and to help the university, that's terrific. But sometimes those things can't be done, right? So that's where the compassion and the empathy comes in, and recognizing that the news that you're giving this person could very well be the most devastating thing that they're ever hearing in their life, okay? If they've got a family, if they've got a spouse, they've got to pay bills. This is just incredibly devastating news, and as much as you can do to help them and their coworkers who are left and may not understand the decisions either, that's always the best, okay? So I think Heather has a few more slides to talk about, then we'll take some questions.
So I'm just actually going to go to the end, if you would, Dan. Just go straight. We'll try and make sure that everyone gets a copy right there. Just that right there, yep. So I just like to draw your attention to the Cardinal Newman Society's resources. So there's a whole page of educator resources that the Cardinal Newman Society has put together, and they're quite good. And so I'd encourage you to look at the policy guidance that the Cardinal Newman Society has, and we've listed the website there for your benefit. There are mission and governance documents, legal and policy issue documents, hiring for mission, human sexuality standards, non-discrimination and diversity standards that you can drop into your policies. So these things are all very helpful. I also would encourage you to consider becoming a Napa Legal Institute member. The Napa Legal Institute was created just for Catholic institutions, so it serves Catholic nonprofit organizations of all sorts, but lots and lots of Catholic schools. And there are a ton of template documents on their website and then their resource data bank as well. So those are two really good sources for you to go to. If you don't have in-house counsel, or you don't have someone that you work with regularly as external counsel, at least that's a good place to start. And so with that, we'll take a few questions. I think we only have about 5 minutes because we started a couple minutes late, so I think we can get away with 5 minutes of questions, Q&A, if anybody has a question. And if not, we're happy to talk individually with anyone who has a question or would like to talk about anything. Thank you so much for your attention today. We really appreciate it.